So I will start with the introduction part. So if a private trust is failed, the resulting trust can be applied where the settlor will receive back the beneficiary interest. So it goes the same with the charitable trust, where if it fails, the court can use the doctrine of Cyprus. It is a doctrine where the settlor's intention in a charitable trust is carried out as near as possible to the original intention in order to give it a legal effect. The court may use the doctrine of Cyprus to avoid the failure of the charitable trust if it has been found that the trust is charitable but the beneficiaries are dead, or it is impractical or impossible to carry out such purposes as specified by the settlor. So the court can make their own interpretation to the settlor's intention in order to carry out such wishes as nearly as it can. So it should be highlighted that the Cyprus can only be used if the trust is at the beginning is not filed as a charitable trust. Unlike in the United Kingdom that has the Charities Act 2002, there are no statutory provisions with regards to charitable trust or doctrine of Cyprus in Malaysia. So next, one of the purpose of doctrine of Cyprus is to prohibit the charitable trust from failing. There are situations where the certain legal documents or account setups such as wills and trusts can no longer be interpreted or distributed. At this point, it can be considered as null or void. So this is where doctrine of Cyprus usually comes into play. Besides that, the court also can choose a new beneficiary who closely match the settlor's original purpose for the charity they were giving to.
Assalamualaikum Madam and my fellow classmates. I'm Eleanor and I will be continuing my group's presentation. There are two conditions or circumstances in which Cyprus may be applied. The first condition is the initial impossibility or impossible ab initio. The second condition is the supervening impossibility or subsequently impossible. For the next part, I will be explaining on the first condition of Cyprus, which is the initial impossibility or impossible ab initio. Initial impossibility imposes that charitable trust was impossible to be carried on from the start. Property is given to charity which ceases to exist at the date the gift takes effect. For example, the charitable organization existed at when the gift was made, but ceased on the date it was to be executed. Charitable trust fails being effective on the date of the gift. The gift will either lapse or fall into residue, in which it becomes resulting trust, or the property will be applied Cyprus by the court. There are three factors that must be considered in applying Cyprus under this condition. Firstly, the width of the charitable intent. Secondly, the defunct or non-existent of charity. And lastly, the continuation of charity in another form. Firstly, in accordance with the width of charitable intent, Cyprus would be applied depending on the width of charitable intent manifested by the donor. If the court finds a general charitable intention of the donor, the property may apply Cyprus. The interpretation of what constitutes to a general charitable intent can be derived from the case of re licet. In the case of re licet, a general charitable intention is the intention of the donor to effect some charitable purpose which the court can find a method to put into operation. A particular charitable intention is when a donor wants his charitable disposition to take effect, but in a specific way, for example, connected with a specific school at a particular place. Secondly, defunct or non-existent charities must also be considered. Hooton stated in the Modern Law Review 1969, ironically, that it's easier to find a general charitable intent in gifts for non-existent charities as opposed to an institution which was existed but had since ceased to exist. In the interest of this consideration, we refer to the case of Re Harwood 1936. The facts of the case is that the Testatrix died in 1934 and left £200 to the Westbecq Peace Society and £300 to the Peace Society in Belfast. Westbecq Society had existed prior to 1934, but ceased by the date to exist. There was no evidence that the Peace Society of Belfast had ever existed. It was held that the former charity failed but the court was able to find an intention to benefit societies whose object was the promotion of peace. And the £300 allocated to Belfast Peace Society was applied Cyprus. Last but not least, consideration must also be made upon the continuation of charity in another form. To illustrate, we refer to the case of Reeve Farrakher in 1912. In this case, the testatrix died leaving a gift to Mrs. Bailey's charity in Rotherhithe. Some local charities had been consolidated under a scheme by the Charities Commission, and funds were held in various trusts for the benefit of the poor in Rotherhithe. But the question arose whether the gift had lapsed. It was held that the gift did not lapse, as the charity was still in existence. The Bailey Trust had not been destroyed by the scheme, and that the consolidated charities were entitled to the legacy. In accordance with this consideration, it's also noteworthy to know that Cyprus can actually apply to unincorporated associations if the gift for the association is for charitable purposes. That is the end for the presentation on the first condition in initial impossibility or impossibility ab initio in applying Cyprus. Moving on to the next presenter.
Apart from the situation where a doctrine of Cyprus is applicable to a charitable trust that is impossible right from the beginning, it is also applicable when a charitable trust becomes subsequently impossible. However, it is important to be noted that its continuance did not depend on the existence of a paramount charitable intention. As per Hanbury and Martin, all that is necessary is that the said property has been given to a charity in a way that the donor did not foresee its returns in any kind of circumstances. To illustrate, a trust fund had been transferred for charity purposes. However, an event occurred to which results the trust fund become impossible, or there exists impractical conditions attached to it. For references, there were two cases in which the doctrine of Cyprus were applied. In the first case is the case of Re Salvin, in which the Court of Appeal had decided that a gift that was given to an orphanage that was closed after the testator's death and before his assets were administered did not lapse. This is due to the very reason that charitable gift becomes subsequently impossible because the orphanage was closed after the testator's death, and thus the doctrine of Cyprus was applied. Looking into the second case, which is the case of Re Robinson, in this case, a testatrix bequeathed a gift to a chapel with the condition that all priests should always wear black gowns every time they are in the pulpit. However, the judge had removed this condition due to its impracticability and applied the doctrine of Cyprus to the said gift.
Assalamualaikum and a very good day. I be to Dr. Rohana and my fellow classmate. My name is Nurfanti Ilani binti Muhammad Skifli. So today we are going to discuss on the matters relating to Cyprus. Although Cyprus is proven to be efficient in governing the charitable trust, there is no such perfect thing in this world. The same goes with the law made by men. There are some challenges on the application of the doctrine of Cyprus. So let's take a look on the first challenges. The first challenge is that we cannot apply Cyprus if the intention made into the trust is very specific. This is because if the intention written is too specific, when or by any chance such unexpected circumstances happen, for instance, insolvency of the non-government organization, the charitable fund will be left unattended. This can be referred to the Really Good case, where the judges held that the language was so particular as to exclude the possibility of finding a general charitable intent. So the court held that the gift failed, and because the level of detail here suggested that particular rather than a general charitable intent. So next, there is no law that governs the doctrine of Cyprus in Malaysia. Although we have adopted many of the UK's legal framework, but there is no law provided to govern the charitable trust fund. The UK, however, has their own Charities Act 2011 to govern such doctrine, ensuring that the benefit will be handed to the right hand. So last but not least, there is an absence of charity commission over this whole charitable matters. The court must establish charity commission to make the doctrine of Cyprus come into existence in Malaysia. We believe that the current system is insufficient to manage matters on Cyprus. Okay, so far as we consider while doing this assignment, here are some recommendations that can be considered in order to give life and govern the doctrine of Cyprus efficiently. First, we recommend that the legislature must enact a separate law to govern charities that regulates, maintains, and registers such charities. And we recommend that we adopted the legal framework from the UK's Charities Act 2011. And furthermore, the legislature must establish a charity commission in Malaysia to govern this matter efficiently and lessen the burden of judiciary. For instance, we can take New Zealand as a model in this matter, where they have their own charity commission and Charities Act 2005 to register, to maintain, to monitor, as well as providing support and education to the charitable sector on good governance and management. We believe that this can lessen the burden of judiciary where they need to decide the case of Cyprus by case basis. So that's all from me. Thank you, and I pass the floor to the next presenter.
In conclusion, there are two conditions in applying for the doctrine of Cyprus, which are the initial impossibility and supervening impossibility. So it is important to remember that the legal principle of Cyprus acts as a savior for unenforceable legal documents or trusts by providing them with relief and allowing them to function and serve their intended purpose. So that's all from our group. Thank you.